it coming through the computer? Check, check, check. Just by unplugging that one face. Just by unplugging the plug.
So I'm going to go ahead. Good morning. My name is Mark Mahundra. I'm members of staff here at Tennessee Valley Unitarian Universalist Church, and today we welcome Chloe Akers, the founder of Standing Together Tennessee. Standing Together Tennessee Incorporated is a nonprofit legal resource center. It was established in response to Tennessee's trigger ban on abortion, which took effect on Thursday. Standing Together Tennessee is not a political entity. They are an organization designed to address the practical effect of our state's new law, which governs the way health pregnant patients in their care. They have a team of highly skilled volunteer attorneys and legal scholars, along with medical providers of various specialties. And I will turn it over to Chloe.
If you guys don't mind, I'm going to have my coffee while I do this because I am very tired. Oh, thank you. Okay, thank you so much for being here. It feels strange. I'm used to talking to like either tons of people or four, so this is a middle ground. So I am here in my capacity as the founder of Standing Together Tennessee. I'm also a practicing criminal defense attorney in my spare time. So one of the reasons why we created the organization that we did is there's a lot of confusion around this law, around what's legal, what's not legal, what we can expect in the future. And personally, when I first read the law, which was after the Dobbs decision came down, I read Tennessee trigger ban, which is now in effect, through the lens of a lawyer. And then I read it again through the lens of a woman, and then I read it again through the lens of a Tennessean, and I think I've probably read it 100 times at this point. This is a really politically divisive issue. People have very strong opinions on abortion. It seems to be a scary topic for people to talk about, but it's incredibly relevant. So I wanted to create a space to have conversations around the practical effects of the law, because they're very genuinely sort of significant and consequential and overwhelming. So I'm going to start today by going through relatively briefly the law itself and how it will function. I have received a list of questions from Mark that I think were submitted in advance, and they're great, so I'll do my best to answer those as well, sort of incorporating them a bit into my presentation. So, the first thing I want to point out is our trigger ban. It's contained in Tennessee Code 3915-213. It's important to understand that the trigger ban is actually based on the language in the law is the exact same language that was in the Human Life Protection Act, which was the bill that was introduced to subsequently become this law in the House and the Senate. So the law makes any law, take any law makes certain conduct a crime, right? It takes conduct and criminalizes it. So when you're reading a law, the very first thing you want to evaluate is the definition section of the law you're reading. Because generally speaking, in the definition section is where you will find the definition of the conduct the law is talking about in the first place. In our law, there are 4 terms, and only 4 terms, that are actually defined: abortion, fertilization, pregnant, and unborn child. Abortion is the conduct that this law criminalizes. And what's really getting stuck in my craw is we have the word abortion, and it has such a political connotation. You hear abortion and your mind goes to so many different things. And this is sort of, I think, by design, right? But in the context of this law, what abortion really amounts to is simply the intentional termination of any pregnancy. I find that when I talk about the law and I answer questions about it, it is sometimes really helpful for me to refer to this as a crime that criminalizes the termination of pregnancy, because that's really what it is. And I think when you take the word abortion out and you start talking about this in terms of the medical procedure that it criminalizes, it becomes a different avenue to see the law, and it opens up some people's minds in a way that I think is really helpful. So the law criminalizes the intentional termination of any pregnancy after the moment of fertilization. However, there is this strange language in the definition section: unless termination is done with the intent to increase the probability of a live birth or to preserve the life or the health of the child after birth. This is a really strange thing to include in this definition, because in working with a lot of the OBGYNs that I have, that concept is actually just an induced labor, okay? So very frequently, labor will be induced for women at full term, before full term, and the intent is never to terminate the pregnancy. The intent is to deliver a fetus so that it lives. So unless you're doing that, unless you're delivering a fetus with the intent that it will live outside the womb, if you are doing anything other than that, you are committing a criminal act of abortion to the extent you're terminating a pregnancy. There is in the definition section, the definition of abortion does not include the removal of a dead fetus. I know that's kind of a crass term, but it's actually the one used in the statute. What they mean by that is, and if you had to ask me, I've chosen a hill to die on, as it were, and it's the following. There's no exceptions to this law. If you follow me on Instagram, or if you've ever met me in the last 2 months, you know this is my personal pet peeve. But removing a dead fetus is not considered an exception to the law. It's conduct that's not even criminalized in the first place because it's not included in the definition of abortion. So if you hear someone say miscarriage management is an exception to the law, they're sort of right, but they're very wrong. Miscarriage management is not considered subject matter that is relevant to this law. It's by definition excluded from the conduct that's criminalized. So to the extent there is no fetal heartbeat, a physician who is emptying the uterus of a woman to assist in that process is not engaging in conduct that is even the subject matter of this law. So if you are removing a dead fetus, by definition, your conduct is not considered criminalized because it's not, by definition, considered an abortion. If you are terminating a pregnancy after the moment of fertilization for any reason, as of Thursday, you are committing a Class C felony in Tennessee, unless you're delivering a fetus with the intent to keep it alive after birth, which would never be confused with a termination of pregnancy. There are exceptions to the law. This is becoming an incredibly challenging part of this conversation. And the irony is, it's really one of the most simple to understand. When you look at the entire law, criminal abortion 3915-213, you have a definition section, you have the section describing the conduct that's criminalized, you have the affirmative defense, which we'll get to in a minute, you have a subsection that talks about unintentional death, that if a fetus is harmed during another process, it's not considered subject matter to this law, and then you have an application section which simply states the pregnant woman upon whom an abortion is performed or attempted to be performed is not going to be criminalized under this law. Nowhere in the law, ever, do you see the word exception. And I try not to be flippant when I say this, but that's the best evidence that there's no exception. If there was an exception, we would see the word exception. I recently pointed out on my Instagram, which is sort of becoming this, I don't know, news source, I suppose, our legislature has created exceptions for other laws, and I think this is really interesting. So, controlled substances, drugs. Our legislature has criminalized the possession of a controlled substance. However, we all know that sometimes controlled substances are prescribed to individuals if they have chronic pain, if you've had surgery, if you've had any number of medical conditions. Your doctor may write you a prescription for, let's say, hydrocodone. If you possess that hydrocodone, a valid prescription, you are not committing a crime. If you possess it without a prescription, you are committing a crime. Our legislature, in the context of drugs, took the precious time they needed to write an actual statutory exception, and it's titled exception. And it says, if you have a prescription, you are not committing a crime. This is really, really important to understand, because the difference between an exception and what our law has as an affirmative defense is the cornerstone of a lot of the concerns in the medical community. An exception takes conduct and makes it not criminal, decriminalizes the conduct entirely. Prescription, no longer a crime. When an exception does that, you as citizens have the certainty of knowing that you're not going to be arrested, hauled into court, and then have to use what's called an affirmative defense to say, I had a prescription, right? You have the certainty of knowing I'm not going to be subject to arrest because I'm not committing a crime, because the law made this decriminalized under certain circumstances. We don't have any exceptions in our law. We only have an affirmative defense. An affirmative defense works like this. If you commit a crime, the affirmative defense does not mean you won't get charged. It doesn't mean you're outside the scope of the criminal conduct. It simply gives you an opportunity to come to court and defend yourself. A common affirmative defense that's used, or that can be used in any number of situations, is insanity, right? The defense of insanity in Tennessee is statutorily recognized. A person who is charged with committing a crime can defend themselves on that ground if they can show certain things by clear and convincing evidence. And so what that means is, it's not saying you didn't commit the crime, you did. It's a justification defense, sort of addressing culpability, right? It's saying, I committed the crime, but I was insane at the time I did it, so I shouldn't be punished. It's not saying you're not going to get charged. So the affirmative defense in the abortion statute functions like this. If you are a doctor in this state, and I have a client who's on call today in Nashville, and a woman comes in with a pre-viable pre-prom. Her water has broken before the fetus would be viable outside of the womb. The standard of care would be to terminate the pregnancy to the extent that removing the fetus at that point is going to significantly reduce the risk of infection and other serious conditions that can occur if that fetus stays in the womb and there's no longer an amniotic sac. the fetus, once water breaks, the fetus's lungs stop developing. So that fetus will never be born alive. If a doctor today has that patient come in down the road at UT Medical Center, and if the doctor determines that terminating is the appropriate medical treatment, and the patient would like to have that medical treatment, the minute the doctor performs that termination, that doctor has committed a felony. There is no way around that. Even though the termination was necessary life-saving medical care, it is still considered a felony under our law. If the doctor is arrested and charged, which they absolutely could be to the extent they committed a crime, they have the benefit of an affirmative defense, which means they can go to court with someone like me, and we can attempt to prove by a preponderance of evidence to a jury that the abortion was necessary either to prevent the death of the pregnant woman or to prevent serious risk of substantial and irreversible impairment of a major bodily function. Fun fact, if you've ever tried a jury trial, and I've tried many, just because you think you prove something or you believe your evidence shows it does not always mean that the jury sees it the same way. So you have this affirmative defense that's available to providers. It's only available after they've been arrested, after they've been charged, after they've hired a lawyer. Usually takes about 9 to 12 months to get a jury trial going in Knox County. Then even when you're at trial, even if you have an excellent attorney who knows the subject matter, who knows how to try cases, who's been in the jurisdiction for a long time, you still run the risk that the jury won't see it your way. And if the jury doesn't see it your way, you lose. And now you are a provider convicted of a C felony. By that time, you have probably already lost your job because most hospitals will fire you once you get charged with a felony. You are effectively unemployable during the time period while you're waiting for trial. And even after trial, even if you do win, what's left, right? So it's really, really critical to understand that if we had an exception for the life of the mother, the doctor who would have performed that same procedure down at UT, they would have the certainty of knowing that they weren't going to be arrested in the first place because that conduct was taken outside the scope of the law. It's been an interesting experience for me to watch the faces of people when they understand that distinction, because it goes from mildly interested to incredibly concerned, as it should be. One of the questions that I had was, do you feel like our trigger law is fairly stable? Do you sense that it may be revised for better or worse? So I will tell you, I have worked really hard in my personal and professional capacity to raise awareness on this particular issue, that our law does not contain any exception. This is consistently being misreported in media at the national level. However, I have been able to work with media at the local level, both in Knoxville and in Nashville, and I can assure you they all understand now this difference. WBIR did a really interesting interview with a number of our state representatives from the Knoxville area. Senator Briggs, Senator Massey, Representative Zachary, Representative Gloria Johnson. And what was really interesting to me is there's a reckoning happening around this issue. There's just no other way to call it. It is what it is. Folks who voted for this bill, and I will tell you, Senator Briggs, who's a physician, he was a co-sponsor of this bill in the Senate. So he didn't just vote for it, he co-sponsored it. Same with Senator Massey. Representative Zachary, he also was a co-sponsor. All three of those folks from the Knoxville area were not just voters in favor of the bill, they were co-sponsors of the legislation. All three have come out in the last week and said some variation of, we might need to rethink this. Briggs, I think, was the most clear. I mean, he straight up said, we need to rethink having an exception. He also referred to this law as one that was just designed to be a placeholder, which is, regardless of your politics, incredibly insulting. When they passed this bill, there was actually no urgency. A placeholder would be something like if Roe v. Wade had been unexpectedly overturned and the legislature had 3 days to pass a bill, so they just put something together to be a placeholder before they came back in session. The legislature passed this bill in 2019, long before Roe v. Wade was overturned. They had plenty of time and no urgency to really work out the kinks and get into the details, and no one did. So, do I think it's going to change? Yes. I think that people in this state, from all political spectrums, I'm talking the farthest left you can get to the farthest right, no one in Tennessee likes to think that their daughters, sisters, mothers, granddaughters are going to die because there's not an exception to a law to allow for a medical procedure when it's necessary to save human life. No one. And I believe that there will be changes made to this law. I hope that no one dies before that happens. I will tell you in my personal capacity, I've called on the governor publicly to hold a special session of the legislature. So this gets to, do you know the procedure for getting a ballot initiative? So I don't know, the procedure to getting a ballot initiative is somewhat complicated. My focus has been on getting the governor to call a special session of our legislature, which doesn't actually go back into meet until January, and amending the bill to have an exception. And if you thought that we didn't have an exception was the worst part of this story, I think it gets worse. So why does everyone think there's an exception when it's so obvious by the language of the law that there isn't? I started to dig into the legislative history of the bill. You can go to the General Assembly's website. Tennessee is actually, it's really interesting. We have one of, I think, the most user-friendly state legislator websites. You can see anything about a bill. You can see who voted for it. You can see who sponsored it. You can see the video that shows who was talking about it and the questions that were asked, both in committee and on the House and Senate floor. I mean, it is right there for all the world to dig into. No one probably does except me, but it's fascinating. So I did that, and I noticed that when the bill was introduced into committee, where it goes before it gets a full vote, this bill was lead sponsored by Senator Dolores Gresham and Representative Susan Lynn. And when they both introduced the bill in the committees that they respectively introduced it to, Senator Gresham was in the Judiciary Committee, Representative Lynn was introducing into the House Committee on Health, Public Health. They both were reading from a document, I'm imagining it's the same document because they used almost identical language, and they both said to the committees, this law creates an exception for situations where the life of the mother is in danger. That's not true. So then I watched when these women introduced this bill on the floor of the House and the Senate for an actual vote. And lo and behold, they both indicated that it was a law that had an exception for the life of the mother. In fact, on the House side, Representative Gloria Johnson from the great city of Knoxville asked very clearly Representative Lynn, does this bill contain exceptions for rape, incest, or life of the mother? And Susan Lynn is seen on video saying no, which is accurate, it does not. She then corrects herself and says, well, actually there is an exception for the life of the mother. So the General Assembly website, to this day, I check it every morning to see if they've updated it. To this day, they characterize the law as creating an exception. You can look at it. You just Google General Assembly Tennessee Human Life Protection Act, and you'll see it's right there. So what we really have ultimately is a legislature that either thought they were passing a bill with an exception and didn't really understand they didn't do that, or we have a legislature that knew they didn't do that and lied. It's one or the other. And so I don't really care at this point which one it was. We can have that conversation for another day. My focus is on convincing the governor to hold a special session, amend the law, and put the exception in that y'all already thought was there in the first place. It's really not that controversial when you understand that everyone appeared to think it already existed when they signed on to the bill. It's only controversial, I suppose, if they knew it was only an affirmative defense, lied about it being an exception and don't really want one. But I'm in the business of giving people the benefit of the doubt. And so I think that this was likely incompetence as opposed to intentional sort of malice. I could be wrong, and some other people have different views on that. But so I think when we talk about the bill being changed, it's really interesting to me because I don't really think Tennesseans are asking for anything that outrageous. Amend the bill to include the exception that by all accounts everyone assumed it had when they signed it and voted for it. Yes.
Can you make available email and or letter that just said, oh, this stuff you just said that we can, as citizens, send
Yes.
governor? But I mean, I'm listening, but I think you can write a better letter than I can.
I will do that. Yes.
We can just start non-partisan.
Sure.
If that's the
If that's what you're interested in doing, yes, yes. And so so I think that we will have an exception for the life of the mother. I think we'll have an exception for rape and incest. I'm hopeful that that will happen. I don't know when, but I think it needs to be sooner rather than later. So that's the gist of the law. There's no exceptions. It criminalizes the termination of a pregnancy after the moment of fertilization, unless the fetus is already deceased. It's a C felony, which means it's punishable by up to 15 years in prison. Another crime that's a C felony would be aggravated assault, robbery. It's pretty, felonies go A, B, C, D, and E, so it's right in the middle of that. Yeah.
So, I'm wondering, and like you've been very clear about this, but I had a conversation with somebody else that's in healthcare. Is there confusion over like medical emergency medications, Plan B pills, IUDs, like I'm hearing that there's going to be, yeah, I'm not going to mask on. Just confusion over like emergency medications that would end a pregnancy. Is that the same? Using the Plan B pills, IUDs. Like there's some gray area there.
There's some gray area there. I will tell you, I'm not a doctor, so I can't speak to.
I mean, just in terms of the law. Do you know if the law?
In terms of the law, Plan B is not, the way Plan B works would not be considered to violate this law because it would not end a pregnancy once the moment of fertilization has occurred. IUDs are a more complicated medical consideration, and that's based on the function of how IUDs work. I will tell you that in certain states, Idaho being one of them, Idaho's law actually addressed IUDs in the definition section and put them outside the scope of the definition. So that's a concern, and it hasn't been addressed yet. Is putting an IUD into a woman going to put you in violation of this law? I don't know the answer. What I do know is that there are OBGYN's offices already in Knoxville that are not putting on IUDs right now. And Plan B, medically, it would never implicate this law because if a pregnancy had begun, if the fertilization had occurred, Plan B would not end the pregnancy. So it's not at issue here. Now, will it be criminalized in another session? Perhaps. There's also, in the context of emergency medical treatment, I will tell you the Idaho decision that just came out on Thursday. So people who really dig into this, like myself, so what I think people don't understand is Tennessee's law and Idaho's law is identical insofar as both states criminalize termination of any pregnancy for any reason. Idaho is the only other state in the country that does not have any exceptions, only an affirmative defense. Texas has exceptions. Okay, so Texas's law says, I have it in this little PowerPoint that prohibited abortion exceptions. The prohibition does not apply if. So Texas has a medical necessity exception. Tennessee and Idaho do not. DOJ sued Idaho on the grounds that their law violated, well, didn't violate, that their law was in contradiction to federal EMTALA, Emergency Medical Treatment Labor Act. EMTALA says you have to treat a patient regardless of their ability to pay if they present to an emergency room with an emergency medical condition. An emergency medical condition is defined under EMTALA to be one that is that puts a person at serious risk, puts their health in serious risk. In Idaho, the district court judge, whose opinion is actually really worth reading, it's very easy to understand, and I think there's parts of it that are really powerful. The district court judge in Idaho said what is pretty clear to anybody. If you've got a law in the state that criminalizes this medical procedure without exception, and you've got a federal statute that mandates that you treat a person, you can't comply with both. It's practically impossible. And so the federal district court in Idaho stopped Idaho from enforcing its abortion ban in situations of medical necessity. Okay, so Idaho's abortion ban is going to continue in all respects. It can be enforced, but it cannot be enforced against physicians who perform an abortion in circumstances of medical necessity at the moment as defined by EMTALA. That was the part of the law that was enjoined by the district court. Why hasn't the DOJ filed in Tennessee? I don't work for the DOJ. I suspect I know why they didn't file in the state of Tennessee. But I don't know the answer for sure. What I will tell you is that Tennessee is in something called the Sixth Circuit. That is a very, very conservative circuit court of appeals. Idaho is in the Ninth Circuit. That is the most progressive circuit court of appeals. When you're deciding where to bring a lawsuit, you, to the extent it's ethical, you choose to bring a lawsuit in the jurisdiction where you're most likely to prevail. So I don't have any idea whether that was a consideration by the DOJ, but I think that is, from just a legal analysis perspective, I used to work in Seattle, so I know the Ninth Circuit well. If I had to choose where to litigate that case, I would have chosen the Ninth Circuit. The other thing is Idaho's affirmative defense, like Tennessee's, has two prongs. The first prong is necessary to prevent death. That's identical. The second prong of Idaho's affirmative defense is different than Tennessee's. The second prong of Tennessee's is necessary to prevent serious risk of substantial and irreversible impairment. Idaho's second provision of the affirmative defense is in cases of rape and incest. So when you think about it in that way too, I think if you're choosing which law to challenge under EMTALA, Idaho's the stronger case for the challenger, which is the government, because it doesn't contain that second portion of the affirmative defense. But I will tell you, the district court's ruling in Idaho really didn't get into the affirmative defense. The district court was like, look, you criminalized this medical procedure, and district court actually used the term full stop, which I thought was really great. He was like, you criminalize this medical procedure, full stop. That's a problem. And that's the exact same analysis that could be applied to the Tennessee law. So there's that in the context of emergency medical treatment. So who can be charged with a crime? This is all the rest of the questions I got pretty much fall into this category. In Tennessee, we have something called criminal responsibility, and we have something called facilitation of a felony. And this is getting into some very, very technical, dicey, legal analysis. And I am not at liberty to give anyone in this room legal advice. We don't have that relationship. I can educate you on what criminal responsibility is. I can educate you on what facilitation is, but I'm not at liberty to say you're okay to do X, not okay to do Y. Criminal responsibility is defined as acting with the intent to promote or assist in the commission of the offense. If you're acting with that intent, if you aid or attempt to aid another person to commit the offense. Now, keep in mind, the offense is abortion, but the only person that can be charged is the provider, not the woman. So if you're a nurse, or you're an anesthesiologist, or you're another physician who's necessary for, let's say, a surgical termination, you can be charged with this crime just the same as the OBGYN. That's thanks to TCA 3911, 401, and 402. That's the Tennessee codified statutory criminal responsibility. It's not a separate crime. It's a theory of culpability that's recognized by law. And it means that if you act with the intent to aid someone in the commission of the crime, you yourself can be charged with the crime. There's really no better example of that than in the context of a surgical abortion, where in order to perform the abortion, you need the anesthesia. You need a nurse to monitor. You need all of these different individuals to keep the patient alive to assist in the procedure. That's by definition criminal responsibility. All of those folks are subject to being charged. Yes?
Would they have to know what the procedure is? I mean,
Yeah. And there's no way around the fact that they would know.
they would have to have knowledge
Mhm.
of all of this.
So the question was, would the other folks in the procedure have to know that they were doing an abortion to have this criminal responsibility applied to them? Yes. As an attorney, I would find it very difficult for someone to say, I was in the room providing the anesthesia and I didn't know this was a termination. Maybe that happens, but I think if you said that, you'd probably be committing medical malpractice. So you got to think about whether the juice is worth a squeeze on that. One of the concerns from the physicians that I've spoken with is it's very difficult. It was very difficult before the trigger ban to convince an anesthesiologist and nurses to participate in certain termination procedures, usually what's called a D&E, dilation and evacuation, which is a procedure performed sometimes in pre-viability but later stages of pregnancy. It's usually when there's a lethal fetal anomaly. It was very difficult to find sort of collateral medical professionals to assist in those procedures, and the fear of OBGYNs is that now it's going to be next to impossible. And if you are a pregnant patient in a rural area of our state where you only have 2 anesthesiologists and they both aren't going to participate and subject themselves to the risk of liability, you could die because an anesthesiologist might say, I don't want to get charged with a felony. There's no exception. So yes, you would have to know what procedure you're participating in. I find it would be very difficult to claim that you don't know, particularly because the nature of all medical procedures, if you're getting a tonsillectomy, if you're having brain surgery, if you're having heart surgery, it's pretty evident what's happening. But I'd be interested to, it's like a great law school question. So that's criminal responsibility. If you're participating in that procedure on any level, you are absolutely eligible to be indicted.
A lot of questions here might be about the person who aids the patient.
I'm getting to that next.
Oh, okay.
Yeah. So people who are aiding the patient. So you all want legal advice. I can't give it to you. I've read the questions. And all the questions are phrased like, what if I do something? I can't answer that. Here's what I can tell you. This law does not apply to the pregnant person. I'll give you a hypothetical, because we use these a lot in law school. If you, for example, drive a patient to Virginia, and the patient has an abortion in Virginia, which is lawful in Virginia, and you drive that person back, under the Tennessee trigger ban, I don't see an ounce of liability under this particular law at this time. If you, for example, were a parent and you drove your 15-year-old to Virginia to obtain medication for a medication abortion, and then you drove back into Tennessee so that she could take those pills in the comfort of her own home, you could theoretically be charged with facilitating the abortion, or you could be charged under the theory of criminal responsibility because you aided. If the person took the pills in Tennessee, then the abortion is occurring in Tennessee, and by virtue of driving that individual, you could theoretically be subject to liability. Now, the question everybody wants answered is, can I advise people of resources? Can I give somebody money who may need to go out of state? These are questions that, as much as you all are going to hate this answer, you need to consult a lawyer, because the answer to these questions are extraordinarily fact specific. Who you're giving money to, under what circumstances, where they're going, how you're giving the money, where did the money come from. These are all really, really important questions that need to be answered to give you any sort of reasonable advice. What I will tell you is this: we live in America, and we still have, for the moment, a First Amendment right to free speech. It's not criminal to tell someone about a website. I know for a fact that Planned Parenthood website is still up, and that organization has a lot of infrastructure in place to work with women who are seeking elective abortion and help them facilitate that. I'm not endorsing their organization by any stretch, but I'm saying that it exists. If you have a person in your life and you say, I think let's go to the Planned Parenthood website, that's not a crime. But when you start getting into driving someone, funding something, then you need to call a lawyer. Or don't, you don't have to, you can just do it. But I think if you want to really evaluate the contours of any liability, you need to seek individualized counsel, because there's about 17, 18, 20 questions that would need to be answered before any lawyer could really give you any meaningful advice on that question. Also, it's important, lawyers cannot help you find ways to break the law. What we can do, and what we do as criminal defense attorneys in this context, is make sure that your conduct complies with the law. So that's also an important distinction. And I know that's not the answer everybody wants. Everybody wants the answer that's like, yes, you can do this, or no, you can't do that. But this is the law, and all answers are very fact specific. And ironically, it's a lot like medicine. We just manage risk. We just try to give you all the information that we can so that you can then make a decision on a course of action that you feel comfortable with. Yeah, I've got another question.
I guess what's a little confusing is if the person with the pregnancy cannot be charged with this law, how can aiding that person
Technically,
who can't be charged with it?
So you're aiding that person, but you're aiding that person in the conduct that itself is criminalized. It's conduct that's criminalized, not necessarily people. It's people who commit that conduct, right? The pregnant person is not subject to prosecution for committing that conduct. Anybody else who does is. So this is why you need also, like, I have many thoughts on that question. We could spend 3 hours going through and managing that scenario. And that's why you need to consult with independent individual counsel. Okay.
This has to do with medical privacy, and I think that was at the heart of the Dobbs decision. And so, we go through and HIPAA all the time. So I guess my question is, legally, how is a doctor or a nurse or any of these people outed when there's a privacy law?
That's a great question. It's actually the very next thing I was going to talk about.
You're welcome.
Okay, so HIPAA. Set aside HIPAA for a minute. Tennessee has a form. This is News Channel 5 in Nashville. I did an interview with them yesterday. They did a great story on this, but I'll tell you now. Tennessee law 68-3-505. It's called Reports of Abortion Information to be Included. Each induced termination of pregnancy that occurs in the state shall be reported to the Office of Vital Records within 10 days after the procedure. There is a form, and it's called Report of Induced Termination of Pregnancy. And this law in Tennessee, which has been on the books for decades, okay, this isn't something that was like just created yesterday. Tennessee's had this law on the books forever, not forever, but for decades, that says if a pregnancy is terminated, it must be reported to the Office of Vital Statistics, which is a division of the Tennessee Department of Health, and they maintain records on this, okay? The form itself obscures some of the patient identifying information. Box number 18 on the form, name of attending physician. That form goes to the Office of Vital Statistics. Everyone thinks HIPAA's great in some respects, but law enforcement has subpoena power. Law enforcement can subpoena any records they want, and HIPAA doesn't shield it if they make the required showing before a judge and a judge signs off on the subpoena order, the court order. So those are two separate things. Let me start with the form. How will law enforcement find out about a termination? Well, the Office of Vital Statistics keeps a dossier. They keep records of every single termination. If a hospital doesn't turn in that form within 10 days, they could potentially be in violation and lose their accreditation as a hospital in Tennessee. So it's not like a choice, it's a shall, not a should. The hospital shall submit this form, and the law actually says in its entirety. So as a criminal defense attorney who's representing physicians in this state currently, I have serious concerns about my client's Fifth Amendment rights against self-incrimination, especially in relationship to a form that the law is mandating the hospital fill out, which in and of itself is evidence of a crime. Like truly, if a prosecutor was able to obtain one of these forms and have it certified and authenticated, it's really all they would need to prove the crime itself. Be like the quickest jury trial from the state side of all time. And then the defense would take, days. So this form is a big problem if you're a provider. It creates an issue if you're a hospital, because what do you do when those are your employees? So this form has to get sent over to the Office of Vital Statistics. Now the next question is, well, can somebody from law enforcement just walk over to the Office of Vital Statistics and be like, hey, Gene, open the filing cabinet, let me pull those forms out? No, okay? The short answer is, well, probably not. What law enforcement would need to access those records is a court order. There are, on the criminal side of things, we have a statute that governs when law enforcement can request a court to issue a subpoena. They have to make sort of some pretty basic showings, just that they have probable cause to believe a crime happened, that they believe this form will be necessary to proving it or investigating it. There's a few other things in there, but they're pretty basic. So to the extent that they can make that showing, which is pretty easy to make, and they know these forms exist, if a judge signs off on that court order, then law enforcement can just, you have to comply with that subpoena if you are the Office of Vital Statistics. Unless you want to object to compliance, and we can get into all of that if you're ever a client of mine. So that's one way in which law enforcement can find out about this procedure that has absolutely nothing to do with your individualized medical records. So HIPAA has no bearing on that form. That form is by law mandated to be filled out and sent to an office of the state of Tennessee. So then you have the next question, which is, okay, so who's going to enforce this law? So Glenn Funk, who's the DA in Nashville, issued a pretty clear press release back in June saying, I will not prosecute any woman who chooses to have a medical procedure to terminate a pregnancy or any medical doctor who performs the procedure at the request of their patient. So Glenn Funk has come out and just said, I'm not doing it. I'm not enforcing this law. Not happening, categorically. That's fine, but meaningless. Because back in 2021, our legislature anticipated that this could happen. So just as a side note, I've been a criminal defense attorney exclusively for 14 years all over the country. There's a growing movement in the prosecution arena of what are called sort of progressive prosecutors. So I worked for 4 years in Philly. The elected DA in Philadelphia right now is a man named Larry Krasner. Larry Krasner was elected to replace a DA who had previously replaced a DA named Lynn Abraham. Lynn Abraham was just the most draconian, hardcore. I mean, we had people on, like, she was putting people on death row. There were exonerations left. I mean, it was bad news. She was a very tough prosecutor. So there's an intervening prosecutor, but then Larry runs for DA. Larry was for years a criminal defense attorney and a civil rights lawyer, incredibly progressive, and he won. And he completely changed Philly's dynamic. Like, a lot of my colleagues who were public defenders in Philly are now working at the Philadelphia District Attorney's Office. They have completely reevaluated the criminal justice system. They got rid of cash bail. They decriminalized marijuana. They created a conviction integrity unit to review all convictions to determine if there were lying police officers, DNA, et cetera, et cetera. So this movement is happening nationwide. And so our legislature back in 2021, bless them, they wrote another law. And this law says if a district attorney general preemptorily and categorically refuses to prosecute all instances of a criminal offense without regard to facts or circumstances, then the state attorney general can just appoint a special prosecutor to do what the district attorney general said they won't. So it's nice that Glenn Funk doesn't want to prosecute the law, I suppose, and I appreciate the sentiment, but it's toothless, it's meaningless. It has no effect. So our state attorney general is new. Just gets more fun, doesn't it? The unknowns become ever more exciting. General Slattery retired. And can you blame him? I mean, at this point, I'd be like, I'm out. Like, I wouldn't want this mess if I was him. So he's retired, and so the Supreme Court appointed a new state attorney general, a guy named Skermetti. I don't know much about this individual. I know he was general counsel for Governor Lee for a while. I know he worked under Mr. Slattery for a long time. I watched his interview with the Tennessee State Supreme Court. He's obviously extraordinarily bright, very, very intelligent. The extent to which he will take the steps necessary to appoint a district attorney pro tem in jurisdictions where a DA refuses to prosecute remains to be seen. I don't know. But I do know that district attorneys are also sort of stuck between a bit of a rock and a hard place. They also have an ethical duty. They have to enforce the law. They don't get the luxury of saying, I don't feel like it, or I think it's a bad law, I don't agree with it. And so this creates a really, really messed up situation where the law itself created a situation where every termination of every pregnancy after the moment of fertilization is a crime. And it's a crime that's very easy to prove because the law also created a mechanism for hospitals to report that criminal activity. And the law puts prosecutors in a position where they have a duty to enforce laws. And there's no exceptions. So the prosecutor doesn't get, if there was an exception, again, we circle all the way back, then a prosecutor's office could say, hey, no, we're not prosecuting this. That was done, and they, absolutely not. But they don't have that exception, so they don't even have a hook with which they can come back and say, we aren't going to prosecute this. So we have a real situation on our hands, and we know the conduct that's criminalized. We know how it can be investigated. We don't know the extent to which it will. We don't necessarily know, that's the other thing. What does it mean to be necessary to prevent the risk of death? I don't know, it's not defined in the statute. What is substantial, what is a serious risk of substantial and irreversible impairment? I don't know. What's a non-serious risk? What is substantial and irreversible impairment? How do we measure that? Is it degrees of pain? I have no idea. Major bodily function, what is that compared to a minor bodily function? Who's to say? There's definitions for that term in other laws and in other contexts, but this law did not expressly include those definitions. So when a legislature chooses not to include those definitions, you have to sort of presume that that was intentional.
Okay, so next. Can you hear me? Yeah. It's on, sorry. Hello. So my question in all of this ambiguity, I'm wondering how much, and I'm not a lawyer, but I'm assuming there is a right to care. So a person shows up at a hospital, say she's had a car accident or something, and if she does not have an emergency procedure, she's likely to die, but they're not sure, right? But the doctors are scared, and they feel like they cannot do it, and the woman dies. Is this law in conflict with like a wrongful death suit because they didn't provide medical care?
Oh, they'll get sued if she dies, no doubt.
But they don't know for sure whether
Would
she
they be
would
able
or
to-
not.
Sure, that would be a great defense to that lawsuit.
So that's what I'm wondering but would it be, so this is where my brain is going, would you sue the hospital for complying with the law? Because they don't know, or would you sue the state for imposing the law? Like, where would that go?
So first of all, I've never filed a lawsuit in my life. I'm a criminal defense lawyer, so I don't know who to sue or how to sue them.
Yes.
I don't know the answer. What I can tell you is, of course, these are all concerns that all these doctors have, like right now. Like they're on call just up the street, and they are all asking the same thing, and they don't know. What I will tell you is this. The OBGYNs that I have encountered in the last 2 months are some of the most incredible, committed, caring, and compassionate doctors. They are not going to let a woman die. They're going to risk prosecution, by and large, because that's not who they are. Now, I can't speak for all of them, but the ones that I have encountered are absolutely going to risk getting prosecuted for a C felony so that women don't die. And our state owes these folks a debt of gratitude. So that's the answer. I don't see a situation, I don't see a world in this state where at least the doctors I have encountered would ever stand by and watch a patient die. But they will be putting themselves at risk of prosecution for a felony, in which case they could lose everything they've worked for. So that's important to understand.
What I have heard, I don't know if it's in this state, but I think it was, of doctors delaying as they're calling attorneys, trying to decide whether they can do something, and that causes some risk to the patient. But my question, and I know this is an opinion question, but the fact that doctors now are leaving the state, that red states can't recruit new doctors, is the legislature going to pay attention to that, and is that going to aid in changing this law?
I hope so. I mean, I think that just falls into the category of the 175 things the legislature didn't think about. So I will tell you, I have spoken to a number of doctors, and they've called me, and I have literally begged. I've said, please stay here for the year. I will work with you on an individual basis. I'll get you through it. I will be your legal counsel if you will stay. Because if they leave, I'm in a church, so I'm not going to say what would happen, but I think we all know what we are not in a good spot. And what's really concerning is high-risk OBGYNs. Those are maternal fetal medicine doctors and perinatologists. There's about 20 to 24 in the state of Tennessee. These are the people that treat the highest risk pregnancies. If they go, we've got a big problem, because these are the people that are going to get the call. These are the folks that are going to get the call from the emergency departments, from labor and delivery, to come down and do the termination, because they're the high-risk OBs. And they're the group of people that we absolutely can't lose any doctors, but we really can't lose them, okay? They're treating all the women who have multiples, women who have serious underlying renal failure, diabetes, heart conditions, pregnancies in women that are older. These people are super well trained. They are very smart. They are very focused. I find it interesting when people are like, how big of a deal can this be? I'm like, there's actually a subset of OBGYN just devoted to high-risk pregnancies. There's that many of them. So I think that what I, Chloe Akers, am doing for the year is begging these people to stay. I'm working with certain physicians in my own practice to anticipate some of the legal issues, to give them the tools that they need so that they don't have to call me, because they should never call me. I got a C in biology. I don't know anything about medicine or science. I should never weigh in on whether a procedure should be performed ever. What I am capable of doing is giving these doctors the tools they need to chart, to evaluate, to make decisions, to know the law inside and out so they can do their jobs without ever calling me beforehand. Now, if they call me afterwards, there's also steps that we take. But yeah, I mean, there is a very genuine concern of delay in care and a denial of care. But I think in this state, at least from the doctors I've encountered, they would sooner go to jail than let a patient die. And I just think that is incredible. And I think when this is all said and done, every single legislator who voted for this bill owes every single one of these OBGYNs an apology, because, man, they have put them in a really tough spot, and these people are brave, doesn't even begin to cut it, what they're doing. So they won't let women die.
I'm glad to hear that. I've heard, though, that like you're not supposed to end an ectopic pregnancy until it bursts, and that puts a woman at higher risk. Things like that are...
No, I mean, look, like, every doctor has to decide how to manage his or her own risk. That's, part of this situation. Ectopic pregnancies, by the way, ending an ectopic pregnancy is considered an abortion under this law. That's something people often don't understand. Pregnancy is defined as having a fetus anywhere in the body, not in the uterus. So if you end a pregnancy after the moment of fertilization, and pregnancy includes a fetus in the body anywhere, ectopic certainly fits into, so yeah, if you give a patient an injection of methotrexate to end an ectopic in an office setting, you're committing a Class C felony. Are you going to be prosecuted for that? I can't imagine a prosecutor who would want to take that case to trial, but I'm a criminal defense attorney. I've seen it all, so I don't presume to know what will be charged and what won't be. But I think, like I said, to the extent that I've talked to the doctors I've talked to, they're not going to let women die, but they're taking on a whole heck of a lot of personal risk, and I think it is going to influence their decision-making process, and it never should. We should never be asking them to weigh out their liberty interests with their medical decision-making. And I think even just the act of doing so takes away precious time and energy and care from a patient who's suffering. So, so I just have the utmost respect and admiration for these doctors and what they're doing.
Hold the questions until Chloe finishes her question.
This was it. The questions were actually helpful to the extent that you guys helped me kind of move through. I hope that it gave you more insight into the law and how it will function. And I think, there's a lot of unknowns, but there's a lot that's known.
Yes, I wondered, there's no feature in our law like Texas private citizens to initiate or
Correct. This is a law that has to be enforced by police and or district attorney generals. We haven't taken that step yet. I think there was another question. Okay.
Can you educate us again on some of the examples you gave as far as aiding the patient? Like, I know you said driving to Virginia would not be considered the felony because the abortion is happening in Virginia.
Mm-hmm.
But then driving to Virginia to get medication for a self-induced abortion or medicated abortion in Tennessee at home would be,
Could be.
okay. And then you said things about donating to organizations?
Donating to organizations is fine.
Okay,
Donating to organizations should be just fine.
okay.
You're gonna have to call a lawyer if you want any more specific information than that. The other thing that people need to understand is that when you consult counsel, your conversations are privileged. Our conversations are not privileged here. So, like I said, to the extent that someone leaves the state of Tennessee and completes the entirety of an abortion in a state where it's legal and travels back, I do not see liability under this law. To the extent you leave the state and come back and have the abortion physically in this state with medication that you may have obtained elsewhere, that is a question that is much more difficult to understand and answer. And if that's a situation that you think you might find yourself in, I would call an attorney to ask that question.
And so do you maybe foresee, with your knowledge of the General Assembly, that they might be making new, more specific bills to particularly criminalize driving people to other states?
Yeah.
Okay.
I mean, when you, I don't know for sure, but I mean, I think my, assessment of our landscape and our sort of
Your
political
gut reaction.
is probably yes.
Okay.
However, I do think that what I see happening right now is some degree of kind of a careful reconsideration of some of the positions that were taken by individual legislators on the issue of abortion, because for 50 years it was a theoretical position only, and it has now become a very real practical position. And regardless of your pro-choice, pro-life, regardless of your take on anything, I think we can all agree that when something goes from theoretical to practical, your thoughts around it tend to change. And I think that's going to happen in our legislature. So I think it's hard to say, because if you look at the legislature and you look at some of the positions advanced by individual legislators in the last few years, you have to look at those opinions through the lens of the understanding that everything they were saying up until June 24th was just a theoretical mumbo jumbo, right? They never had to actually consider that position being put into practice. Now that these positions have to be put into practice, I think I'm not relying exclusively on things they said pre-Dobbs to reflect positions they may hold post-Dobbs, because those are two different universes. And I think we've seen this a lot in some degree. I mean, I'm in criminal defense. We've seen an evolution, especially in the Republican Party, with regard to criminal justice reform. And there has been a very different evaluation of some of those issues from people who 10 years ago might have taken a very different approach. And so I never want to pigeonhole anyone into, I want to give grace to our legislators to change and modify and evolve their thoughts on this, and I expect that they will. So I don't know, could they create a law that tries to criminalize interstate travel? Maybe, but I'm seeing something, I don't know, maybe a little different. I think people are starting to look at this through a more practical lens, and I hope that that's the case. Mm-hmm.
Suppose that someone doesn't have much money, and is pregnant and needs advice. Do you know of any groups in town that could offer that without, are there any lawyers, groups that are free or low cost that would counsel someone who is pregnant and didn't have a lot of money?
Well, I would.
I'm just curious.
There's Legal Aid of East Tennessee, which is a great organization.
Okay.
And there's lots of lawyers in Knoxville who I think would be willing to work at a reduced rate for folks to give some individualized legal advice. My organization, Standing Together, is actually not going to be providing any direct legal representation or advice, at least not initially. We're primarily and exclusively an education-based organization. Our focus is just on educating the community, including doctors, lawyers, and sort of patients about the law. One day we may evolve and have direct representation, but we don't now. But there's a number of lawyers that I know would be willing to probably work at a reduced rate, and Legal Aid of East Tennessee is a great resource. The Knox County Public Defender's Office doesn't usually take cases before someone's been charged, but I don't know if they're going to be rethinking that in consideration of this law. I think that's something they can decide. So yeah, I mean, I think that there's folks out there who would consider working with people, and I think there's a lot of great organizations that already exist to help women who are pregnant and need to consult with folks and try to figure out how to manage that if they're not interested in being pregnant anymore. I mean, I will tell you that I think the biggest concern, one of the biggest concerns, is when you think about lethal fetal anomalies. And what I mean by that is there will be women who, between now and January, when our legislature goes back into session, there will be women who are pregnant who find out at the 18 or 19 week mark during a fetal anatomy scan that their baby has a lethal fetal abnormality. This is a situation where a fetus is being formed without a skull or without, full lungs or, organs on the outside of the body. I mean, there's a host of situations like that where the fact that the fetus is developing in that way might not necessarily cause the death of the pregnant woman or cause serious risk of substantial and irreversible impairment of a major bodily function. And if that woman can't afford to travel out of state to terminate the pregnancy of a fetus that will never live, then that is a real concern, because that's when you start talking about a situation where it's not necessarily gonna be something like a medical emergency. It's more about saving the woman's life. That's a different situation, and I think that's one that really deserves to have some thought and examination too by our legislature, because in those circumstances, women who can't afford to travel outside of the state to terminate, if that's what they wish to do, they'll be forced to deliver a fetus that will die. And if you deliver any baby, you yourself are at risk of death. So it presents a very confounding situation. And there are certainly, from my discussions with the OBGYNs I work with, there are certainly situations where women and families will get that diagnosis and they will choose to deliver the fetus and they want to be with the baby, which I think is incredibly admirable and also equally brave. But there are times where women will elect to terminate in those situations because they don't want to risk death by carrying to term a pregnancy that will never result in a baby. But that choice no longer exists. So now it's either travel to another state for a termination in that circumstance or don't. And that's very concerning too, and I think cruel to women. I'm gonna take one more question. Go ahead, Mark.
I just had a quick question. I wanted to get clarification. So if an organization has specific questions about what they have going forward, they should look to retain a lawyer and ask those questions? Okay. All right, that's just wanted to clarify that.
Yeah, I think that's the most prudent thing to do. Or you can not retain a lawyer and just do your thing. But if you want to make sure that your conduct is conforming with the law, I would encourage anyone. If you have a question in your head as to whether doing something could break a law, call a lawyer. It's that simple. So I hope this was helpful. I know it's not all the answers, but at least it raises the questions, which I think is important. So thanks.
Thank you very much for coming here today.